We begin our exploration of concurrent estates, a fundamental topic in property law tested extensively on the multi-state bar examination. Concurrent ownership exists whenever two or more persons hold simultaneous rights in the same real property. This concept simply means shared ownership. For the bar exam, you must master three primary forms of concurrent ownership. First, we have tenancy in common, often abbreviated as TIC. Second is joint tenancy, or JT. And finally, the specialized form known as tenancy by the entirety, or TBE. While all three estates permit shared possession of the entire property, the critical distinctions that examiners focus on revolve around two key concepts. The first is the right of survivorship, which dictates how an interest passes upon a co-owner's death. The second is the rules governing severance, which determines how the estate can be altered during the owner's lifetimes. Understanding survivorship and severability is key to distinguishing these three estates. Now we turn our attention to the first specific estate, tenancy in common, or TIC. For the bar exam, remember this crucial rule: tenancy in common is the default concurrent estate. If the language used to create the ownership is ambiguous, or if the required unities for joint tenancy are not met, the law presumes a tenancy in common. The only unity required to create a TIC is the unity of possession. This means every tenant has the right to possess and use the entire property, regardless of the size of their fractional share. Unlike joint tenancy, which we will discuss next, tenancy in common features absolutely no right of survivorship. When a tenant in common dies, their interest does not automatically pass to the surviving co-owners. Instead, that interest is treated as any other asset. It passes according to the deceased owner's will, or if there is no will, through the laws of intestacy. This flexibility in transfer is a defining feature of TIC. Having established tenancy in common as the default, we now move to the estate that requires specific formalities for its creation: joint tenancy, or JT. Joint tenancy is defined by the presence of the four unities. If all four are present at the moment the estate is created, the right of survivorship automatically attaches. These four unities are: first, the unity of possession, the right to possess the whole, just like tenancy in common. Second, the unity of interest, meaning all joint tenants must hold equal, undivided shares. Third, the unity of time. All interests must be acquired simultaneously, at the same moment. And finally, the unity of title. All interests must be acquired through the same instrument or document. To help you remember these, use the mnemonic PITT: possession, interest, time, and title. It is absolutely critical to understand that if even one of these four unities is missing at the moment of creation, the law will not recognize a joint tenancy. Instead, the estate defaults immediately to a tenancy in common. Now that we understand the strict requirements for creating a joint tenancy using the four unities, we arrive at the feature that truly distinguishes it from tenancy in common: the right of survivorship, known formally as jus accrescendi. This right is the cornerstone of joint tenancy. When any joint tenant dies, their interest in the property does not pass to their heirs or beneficiaries via a will. Instead, that interest automatically and immediately vests in the surviving joint tenant or tenants. This mechanism bypasses the entire probate process, offering a swift and certain transfer of title. This automatic vesting is precisely why parties often choose joint tenancy over tenancy in common, where interests pass according to testamentary or interstate succession rules. Remember, in tenancy in common, death triggers a transfer; in joint tenancy, death triggers absorption by the survivors. We just established that joint tenancy provides automatic transfer upon death. However, This unique structure is fragile and can be destroyed while the tenants are still alive. This process is called severance. Severance occurs when an action taken by one joint tenant destroys one of the essential four unities, thereby terminating the joint tenancy and converting the ownership interest into a tenancy in common among the remaining parties. Crucially, once severed, the right of survivorship is permanently lost for those interests. The most common and straightforward method of severance is an inter vivos conveyance, a sale or gift of one joint tenant's interest to a third party. Consider joint tenants A and B. If A conveys their interest to a new party, C, the unity of title and time between A and B is broken. A is out, and B and C now hold the property as tenants in common. B no longer has the right of survivorship over C's share, and C certainly never had it. The estate is now a tenancy in common, meaning B and C's interests will pass according to their wills upon their respective deaths. While unilateral conveyance is common, joint tenancy can also be severed through other means. First, severance can occur by mutual agreement. If all joint tenants agree in writing to terminate the joint tenancy, they effectively destroy the necessary unities, and the estate becomes a tenancy in common. Second, severance can be achieved through a partition action. This is a lawsuit brought by one joint tenant asking the court to divide the property. A partition can be voluntary, where the parties agree to the division terms, or judicial, where the court orders a sale or physical division of the property. Finally, be aware of a split in authority regarding encumbrances. A minority of jurisdictions hold that one joint tenant granting a mortgage or a long-term lease severs the joint tenancy immediately upon execution. However, the majority rule treats these acts merely as encumbrances that terminate only upon the death of the encumbering tenant, meaning the joint tenancy survives the mortgage itself. Regardless of the method, the key takeaway is that severance always results in a tenancy in common. We have now explored tenancy in common and joint tenancy, including how joint tenancy can be severed. We now turn to the third major concurrent estate, tenancy by the entirety, or TBE. This estate is highly specialized, as it is available exclusively to married couples, or in some jurisdictions, registered civil union partners. To create a valid tenancy by the entirety, 5 unities must exist at the time of creation. These include the 4 unities required for joint tenancy: possession, interest, time, and title, plus the crucial 5th unity, the unity of person, which signifies the legal unity of marriage. Because the spouses are treated as a single legal entity, TBE offers the strongest form of creditor protection among concurrent estates. Generally, the property held in tenancy by the entirety cannot be attached or sold to satisfy the individual debt of only one spouse. This shield is a primary reason why married couples often choose this form of ownership where available. We conclude our discussion by examining the termination of tenancy by the entirety. Unlike joint tenancy, tenancy by the entirety cannot be unilaterally severed by one spouse conveying their interest, because the spouses are treated as one legal unit. Termination occurs only in 3 specific ways. First, by the death of one spouse, where the survivor takes the whole property via survivorship. Second, by the mutual agreement of both spouses to terminate the estate. And third, critically, by divorce. Divorce automatically destroys the unity of person, immediately converting the estate into a tenancy in common. Now, let us review the critical distinctions across all 3 concurrent estates for your final preparation. Tenancy in common is the default, requiring only possession, and crucially, it lacks survivorship. Joint tenancy requires the 4 unities, includes survivorship, but it is severable, usually by conveyance. Finally, tenancy by the entirety requires 5 unities, includes survivorship, and provides the strongest creditor protection, shielding the property from the individual debts of either spouse. Remember these core differences: survivorship, unities required, and creditor protection level. This concludes our overview of concurrent estates.